Why in the past, if you are old enough to remember the before times, why in the past didn't prosecutors go making inflammatory public statements, usually, while they were in the middle of prosecuting someone or handling any sort of legal matter whatsoever? You may recall the phrase, no comment. We cannot comment on pending litigation, that kind of thing. So here they are commenting on pending litigation. At least that's what that then gives Mr. Comey the ability to argue. So by saying things publicly about his case, both the president and the Department of Justice officials, it taints the case in some way. At least there will be hearings, okay? And now we're in those hearings. That's what's happening here. Maybe I should show you the docket. How about that? There. Okay, so here's the docket, and I've got it in reverse. There are 212. The frame of my camera is cutting off the top of my head. Yeah, that's probably true. I can, there we go. There are 212 docket entries here. A lot of it is motions to dismiss and replies, and other interesting motions that are just beyond the scope of this video, like a motion for a bill of particulars and a motion for disclosure of the grand jury proceedings, that they're going to investigate what was done before the grand jury. So let's go into it a little bit here. Mr. Comey has repeatedly spoken out about President Trump's conduct in office. In response, President Trump has resorted to personal attacks. During his first term, President Trump openly discussed deploying the IRS against Mr. Comey. President Trump revoked John Brennan's security clearance because of his criticism while threatening to do the same to Mr. Comey. President Trump tweeted about prosecuting Mr. Comey, sending him to jail, among other personal insults and attacks. And then I believe there was a tweet that was sent to Pam Bondi about it's a disgrace to get this guy out and we have to do something, basically, I think was what he said. So skipping ahead then, so that we don't go over the thing that we already went over for too long, there was then the second motion to dismiss for the unlawful appointment of Lindsay Halligan, I believe her name is, who was unlawfully appointed to her position as interim U.S. attorney. Normally, there is a procedure to these appointments, and that procedure may or may not have been followed here. Let's see what the motion to dismiss has to say. Congress enacted 28 U.S.C. Section 546 to address vacancies in the offices of the U.S. attorneys. Subsections A and B provide that the Attorney General may appoint a United States attorney for the district in which the office of the United States attorney is vacant. The U.S. Attorney's Office for the Eastern District of Virginia had a vacancy. Mr. Todd Siebert, I believe his name was appointed. His appointment expired 120 days after the appointment by the Attorney General. At that time, the district judges for the Eastern District of Virginia exercised their appointment authority to unanimously retain Mr. Siebert as interim U.S. Attorney. The Trump administration began pressuring Mr. Siebert to indict Mr. Comey and Letitia James. When Mr. Siebert appeared unwilling to do so, Trump told reporters that he wanted Siebert out, and Siebert resigned on September 19th, 2025. President Trump publicly posted and later withdrew this famous statement that we have seen before, but we're going to check out again. Pam. I have received over 30 statements and posts saying essentially same old story as last time, all talk, no action, nothing is being done. What about Comey, Adam Shifty Shift, and Letitia? They're all guilty as hell, but nothing is being done. We can't delay any longer. It ends. It's killing our reputation and credibility. They impeached me twice and indicted me over 5 times. Over nothing. Justice must be served now. Less than 48 hours after Mr. Trump's post, Ms. Lindsay Halligan was sworn in as interim U.S. Attorney for the Eastern District of Virginia. Ms. Halligan was a special assistant to the president and a White House official. She previously worked as an insurance lawyer and personal lawyer for President Trump and lacks prosecutorial experience. On her 4th day in office, she sought the grand jury indictment of Mr. Comey. Now, this is going to come back to haunt us because now we're learning that the way she sought the grand jury indictment may have been fraudulent. Certainly may have violated procedure, but may have been fraudulent. Now, fraud requires intent. I'm not accusing anyone of, anything they didn't do, but it certainly deserves an investigation, and you'll see. No other prosecutor from the U.S. Attorney's Office for the Eastern District of Virginia participated in Ms. Halligan's grand jury presentation. She presented the grand jury with a 3-count indictment. This is important. 3-count indictment. The grand jury returned no true bill on the first count. That means they don't agree with the first count. So they stayed well past normal court hours, and the grand jury returned a true bill on the other 2 counts only by a slim majority. Only Ms. Halligan signed the indictment. Now, we are learning now, and this is probably in one of the later motions to dismiss, but we are learning now that she did not present the 2-count indictment that is the operative indictment in this case, that she did not present the 2-count indictment back to the jury, the grand jury. So what it appears that she did, and this is my understanding. I, again, do not want to accuse someone of something they didn't do, but there's enough here to be very concerned. What it appears that she did was they didn't approve the 3-count indictment. Only count 1 failed. They did approve counts 2 and 3. And normally, you would then take counts 2 and 3, present only those counts in a new indictment, revised indictment, bring it to the grand jury, have them review it. Yep, it's the same one. They sign off, present it to the judge. She did not do that, is my understanding. My understanding is that she brought a 2-count indictment with her and had the grand jury foreman sign off on it without presenting it to the grand jury. So that's going to come back to haunt this case too. Count 1 was making false statements to Congress. Count 2 was corruptly endeavoring to influence, obstruct, and impede. And count 3, I guess those are the 2 counts. Okay. So unlawful appointment. We'll have to see what the judge says about that. That is the second motion to dismiss, is unlawful appointment of Lindsay Halligan. And again, sounds like something you should be looking into. Why was Trump's personal assistant, and insurance lawyer, why are they prosecuting a criminal case, I think for the first time in her life, in her career? All right, so we have more motions to dismiss. Here's one that we haven't seen before, though. This is the motion to dismiss filed October 30th for fundamental ambiguity and literal truth. As explained in the accompanying memorandum, Count 1 seeks to punish Mr. Comey for responding to Senator Ted Cruz's fundamentally ambiguous questions with literally true answers. As a matter of law, neither those questions nor those answers can serve as the basis for a violation of the law. Count 1 must be dismissed. Count 2 rests on the same allegedly false statements and should be dismissed for the same reasons. On May 3rd, 2017, Mr. Comey voluntarily testified at the Senate Judiciary Committee's annual FBI oversight hearing. As relevant here, Mr. Comey engaged in the following exchange with Senator Charles Grassley. Grassley: Director Comey, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? Mr. Comey: Never. Senator Grassley: Question 2, on relatively related, have you ever authorized someone at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation? Mr. Comey: No. 3 years later, September 30th, 2020, Mr. Comey voluntarily appeared before the same committee at a hearing on the Crossfire Hurricane investigation. As relevant here, Mr. Comey engaged in the following exchange with Senator Ted Cruz. Cruz: On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, have you ever been an anonymous source, etc. You responded under oath, never. He then asked you, have you ever authorized someone, etc. You responded under oath, no. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth? Mr. Comey: I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017. Senator Cruz: So your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says the contrary, is not telling the truth. Is that correct? Mr. Comey: Again, I'm not going to characterize Andy's testimony, but mine is the same today. And this is a very wise move. I would do the same thing. I would rely on my previous testimony without restating it, because why would I open myself up to more attacks when, one, you're in an adversarial environment. These people are there to attack you. They are not your friends. They are not there to help. They are not there to simply get information or simply accept the truth. They are there to, they have an agenda. It could be a good agenda, it could be a bad agenda, but they have some kind of agenda. So it's not necessary to cooperate more than necessary, because you're just putting your butt out there on a limb and the limb's going to break. So it is completely normal for a trained law enforcement officer / attorney, career prosecutor here, to just rely on his previous testimony. So then if you understand what the basis for the indictment is, what's in there, like who has lied here in a way that can be supported by reasonable suspicion or more probable cause. What are the chances of this prosecution actually working? Based on this testimony, the government has charged Mr. Comey with a 2-count indictment. The government attempts to satisfy the elements of a defendant knowingly making a false statement by claiming the defendant willingly and knowingly made a materially false, fictitious, fraudulent statement in a matter within the jurisdiction of the United States by falsely stating to a United States senator that he had not authorized someone else at the FBI to be an anonymous source in news reports. The statement was false because James Comey knew that he in fact had authorized person 3 to serve as an anonymous source in news reports. Okay. And I guess person 3 refers to Daniel Rickman. Okay. So that's the basis for the fundamental ambiguity and literal truth, is that testimony right here. And you can sort of judge for yourself whether you think that's good enough. The government will have to prove that Comey did know Daniel Rickman or Andy McCabe or whoever was leaking things. And I guess it's going to be somebody's word against somebody's word. I don't know how they're going to prove that, especially considering they're talking about things that are 8 years old. Good luck. And then we have a new one that was just filed. We'll spend a little bit more time on this one. James Comey moves this court to dismiss the government's indictment. The case should be dismissed because the grand jury never received the operative indictment. A grand jury may only indict if 12 jurors concur, but 12 jurors did not concur on the operative 2-count indictment. The grand jury rejected only the indictment that the government presented to it. The government's attempt to prosecute Mr. Comey without a valid indictment of a grand jury violates the Fifth Amendment. Dismissal is independently warranted because of the government's misconduct. The government relied on information it obtained in violation of the Fourth Amendment and attorney-client privilege, and it made serious misstatements of law to the grand jury. Collectively, those violations raise grave doubt that the decision to indict was free from the substantial influence of the government's misconduct, warranting dismissal with prejudice. A bunch of stuff has gone down here, so let's take a look. In previous filings, Comey has identified multiple independent reasons why this case is legally flawed. This motion focuses on fundamental errors in the grand jury process itself. These errors reflect the reckless and ill-conceived nature of his prosecution. A president, intent on prosecuting Mr. Comey before the statute of limitations expired, directed the appointment of a White House aide, Lindsay Halligan, as interim U.S. attorney, and she rushed to secure an indictment while flagrantly violating basic grand jury rules in the process. Those grand jury errors warrant dismissal twice over. First, the case should be dismissed because the grand jury never received the operative indictment. We already went over that a little bit, so I'm going to skip. Second, dismissal is independently warranted because of the misconduct of the government before the grand jury. Mr. Comey has extensively documented that misconduct in previous filings. Judge Fitzpatrick's recent opinion details a disturbing pattern of profound investigative and prosecutorial missteps that have undermined the integrity of the grand jury proceeding in the case. Among other things, the government executed search warrants in a manner that violated the Fourth Amendment and relied on the information obtained from those searches as part of its grand jury presentation, relied on attorney-client privilege information as part of its grand jury presentation, and made serious misstatements of law to the grand jurors. Collectively, those violations raise grave doubt that the decision to indict, which the grand jury reached only by a narrow margin and after lengthy deliberations, was free from the substantial influence of the government's misconduct. They're talking about ECF 191 at 24. Let's take a look at what that is. Here's ECF 191, the memorandum opinion of the judge. Yeah, let's take a look at that then next. So they must have got the grand jury disclosure, and we're going to get to take a look at what happened. We'll look at 191 in just a moment. The putative indictment should therefore be dismissed. Then that dismissal should be with prejudice because of the flagrant nature of the government's misconduct, particularly combined with the flagrantly unconstitutional initiation of this prosecution at the president's behest. On September 25th, Ms. Halligan sought a grand jury indictment of Mr. Comey. No other prosecutor participated at any stage of the proceedings. Besides Ms. Halligan, the only other individuals who participated in or witnessed the presentation were the grand jurors, the court reporter, and an FBI agent, Agent 3, who appeared as a witness. The record establishes that Ms. Halligan presented the grand jury an indictment with 3 counts. Count 1 for falsely stating to Senators Lindsey Graham and Josh Hawley that he did not remember being taught of Hillary Clinton's approval of a plan concerning Donald Trump and the 2016 election. Whatever the heck that means. Count 2 was the Senator Ted Cruz thing that we read, and count 3 was making false statements before the Senate Judiciary Committee. The proceedings before Judge Fitzpatrick and the government, representations to the defense, and this court established 4 important facts. First, Ms. Halligan relied exclusively on the alleged false statements that served as the basis for counts 1 and 2. The government first informed the defense of that fact in a meet and confer on November 12th. It then identified only those 2 statements as examples of allegedly false testimony in its opposition to Mr. Comey's motion for a bill of particulars. Second, as Judge Fitzpatrick found, Ms. Halligan suggested to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. The rest of that's redacted. Third, Judge Fitzpatrick found that Ms. Halligan suggested to the grand jury that they did not have to rely only on the record before them to determine probable cause, but could be assured the government had more evidence, perhaps better evidence, and that evidence would later be presented at trial. Fourth, Judge Fitzpatrick found materials retained and searched in violation of the Fourth Amendment formed the cornerstone of the grand jury presentation. The government had originally obtained these materials pursuant to a 2019 warrant that authorized the government, as part of the Arctic Haze investigation, to search for materials related to potential violations of the law. Although the Arctic Haze investigation concluded in 2021, the government retained those materials and searched them in 2025 without seeking a new warrant. That's important. Agents reviewed and printed privileged communications between Mr. Comey and his lawyer and provided what the government has characterized as a limited overview to the FBI. In turn, Ms. Halligan extensively questioned the FBI about communications between Mr. Comey and Mr. Richmond during Agent 3's testimony before the grand jury. The grand jury deliberated more than 2 hours. At the end, it returned no true bill. As the foreperson of the grand jury of this court, at a session held in Alexandria, Virginia, I report that 12 or more grand jurors did not concur in the finding of an indictment in this case. The foreperson signed the report. Although the defense lacks complete information about the exact order of subsequent events, Ms. Halligan's November 14th declaration, the government's filings, and a transcript suggest the following events occurred. After the close of deliberations, the grand jury foreperson informed the U.S. Attorney's Office grand jury coordinator that the grand jury had voted to reject count 1, but had voted to approve counts 2 and 3. The grand jury coordinator then informed someone from the U.S. Attorney's Office about that result. The then First Assistant U.S. Attorney Maggie Cleary informed her of the grand jury coordinator's account. Ms. Halligan proceeded to the courtroom for the return of the indictment in front of the magistrate judge. At some point before appearing in front of Judge Valla, Ms. Halligan and the foreperson signed the last page of the report of a grand jury's failure to concur in an indictment, and someone from the U.S. Attorney's Office printed a new indictment that included only 2 counts. Count 1 of the new indictment corresponded to count 2 of the previous, count 2 of the new corresponded to count 3 of the previous. So they eliminated count 1 of the previous. Ms. Halligan and the foreperson signed the new indictment, but there is no record of the grand jury seeing the new indictment, let alone voting on it. Ms. Halligan and the foreperson then appeared before Judge Valla. They presented Judge Valla with both the no true bill and the new 2-count indictment. After the foreperson stated that the jury had failed to find probable cause on count 1, Judge Valla asked the foreperson several questions. Judge Valla, okay, when you say 1 count, I'm looking at case 25 CR 272, US of A versus Comey. I have an indictment with 2 counts that my courtroom deputy read. That looks to be signed by you, ma'am. Foreperson, yes. Judge. And it says 14 grand jurors concurred in the indictment, and then I have a report of the grand jury's failure to concur in an indictment, and it just reports that has 3 counts, and it says that the grand jurors did not concur in the finding of an indictment. The foreperson. So the 3 counts should just be 1 count. It was the very first count that we did not agree on, and counts 2 and 3 were then put in a different package, which we agreed on. So they separated it. Sorry, I didn't mean to interrupt you. So you voted on the one that has the 2 counts. Foreperson. Yes. Judge Valla then asked Ms. Halligan for an explanation of what happened. The court says, so this has never happened before. I've been handed 2 documents that are in the Mr. Comey case, and they are inconsistent with one another. There seems to be a discrepancy. They're both signed by the foreperson. One says it's a failure to concur. It doesn't say with respect to 1 count. It looks like they failed to concur on all 3 counts. So I'm a little confused as to why I was handed 2 things with the same case number that are inconsistent. Ms. Halligan. So I only reviewed the one with the 2 counts that our office redrafted when we found out about the 2 counts that were true billed, and I signed that one. I did not see the other one. I don't know where that came from. The court. You didn't see it? Ms. Halligan. I did not see that one. So your office didn't prepare the indictment that they... No. I prepared 3 counts. I only signed the 2 count. I don't know which one with 3 counts you have in your hands. Okay, well, it has your signature on it. Okay, well... Judge Valla then instructed the foreperson to modify the report of a grand jury's failure to concur by hand to reflect that it applied to only 1 count. The report filed on the docket reflects that modification. So this would be a Fifth Amendment due process violation, all kinds of violations, court procedures, legal procedures. It'd be very strange if this was not dismissed under these circumstances, or if James Comey is mischaracterizing something here to the point that the judge will find that his characterization is not correct. In Gaither, the grand jury voted to present the defendants for grand larceny, after which an indictment was drafted by the U.S. Attorney's Office and signed by the foreman. But the grand jury did not consider the case again or vote on the actual indictment. The court ruled this was error because Rule 6 requires 12 jurors approve the actual indictment. The grand jury did not approve the operative indictment here, therefore must be dismissed. This is mostly argument, so I think we're going to skip ahead. So he's asking for a dismissal with prejudice, of course, for yet another reason. But wait, there's more. So here's the memorandum opinion of, I think, the magistrate judge. William Fitzpatrick, magistrate judge. The court finds the record in this case requires the full disclosure of the grand jury materials. The court recognizes this is an extraordinary remedy, but given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused. October 13th, the government moved for implementation of a filter protocol to govern its handling and disclosure of privileged material. The material was seized in 2019 and 2020 pursuant to a court-authorized warrant or warrants in a different district and as part of a separate investigation. The defense opposed the motion on the grounds the information the government sought to review was improperly retained after the conclusion of the prior investigation. Rather than institute a filter protocol, the defense asked the court to direct the government to disclose information related to the acquisition and prior use of the material it sought to review. The defense argued that its concerns with the government's respect for and ability to safeguard the defendant's attorney-client privilege materials are not merely hypothetical, because the lead case agents may have been exposed to attorney-client privilege materials. On October 29th, District Judge Nachmanoff entered an order finding that briefing on the government's proposed filter protocol raises several legal questions that must be resolved. The court appointed the undersigned magistrate judge to preside over all proceedings related to this privileged materials request. We're going to skip ahead. There's a legal standard for disclosing secret grand jury proceedings. They are not normally disclosed. There must be a particularized need, a showing of particularized need that outweighs the strong interest in maintaining the secrecy of the grand jury proceedings. In 2017 here, The U.S. Attorney's Office for the District of Columbia initiated an investigation referred to by the FBI as Arctic Haze. This investigation concerned an allegation of unauthorized disclosure of classified information to a New York Times reporter, which appeared in a 2017 article titled, "Comey Tried to Shield the FBI from Politics, Then He Shaped an Election." The investigation focuses on the article's inclusion of classified information related to one of the factors that influenced Mr. Comey's decision as then FBI director to unilaterally announce the closure of the FBI's investigation into then presidential candidate Hillary Clinton's handling of classified material while she was Secretary of State. Daniel Richman, Columbia Law School professor, personal friend of Mr. Comey, and former special government employee at the FBI during Mr. Comey's tenure, was quoted by name in the article and was the subject of the U.S. Attorney's investigation. The FBI obtained 4 search warrants, a hard drive, an iCloud account, an iPad, and an iPhone belonging to Mr. Richman, as well as email accounts used by him. The warrants authorized agents to search for and seize information created or stored between March 1st and May 30th, 2017 that constituted evidence of violations of the law. The information seized during the investigation is the center of the current dispute. The government took modest, and as it turned out ineffective, steps to identify and isolate potentially privileged information contained in the materials pursuant to the Richmond warrants. The government permitted Columbia University to review the emails and withhold private or otherwise sensitive information. The government provided Mr. Richmond and his counsel an opportunity to review the materials seized. The government claims that the documents and communications identified as privileged were never reviewed as part of the investigation. However, the government never engaged Mr. Comey in this process, even though it knew that Mr. Richmond represented Mr. Comey as his attorney. And 3 of the 4 Richmond warrants authorized the governments to search his devices days after an attorney-client relationship had been formed. According to an April 29, 2020 letter from Mr. Richmond's then attorney to the government produced to the court ex parte by the defense, the Department of Justice informed Mr. Richmond that the data it obtained from his iCloud account extended to August of 2019, well outside the scope of the warrant and well past the date on which Mr. Richmond was retained as Mr. Comey's attorney. The same letter further states that the Department of Justice informed Mr. Richmond it had seized data from Mr. Richmond's hard drive that extended to June 2017, again well into the period in which Mr. Richmond represented Mr. Comey. So what are they talking about here? If you seize an attorney's hard drive and you need to search it, you have to give the attorney and any other interested party a chance to mark or tell you where the privileged information is. Where do you keep your client file or something like that? And they didn't do that for Mr. Comey, who is very material to that information, very, very connected to that information. So he should at least have been allowed to mark privileged information. They can have a fight over whether it's privileged later, but they didn't even do that part. So they got to review it potentially without giving him a chance to respond. Again, due process is all about having an opportunity to respond after proper notice, and that's very important. It's a foundational part of the U.S. Constitution. At the time the warrants were executed, the government was aware not only that Mr. Richmond represented Comey, but also that he maintained ongoing attorney-client relationships with other individuals. Mr. Richmond's devices contained potentially privileged communications. The government made a conscious decision to exclude Mr. Comey from the filter process, even though Mr. Comey, as the client, is the privilege holder. The government's claim at the November 5th hearing that Mr. Richmond was in a position to effectively assert Mr. Comey's privilege is entirely unreasonable. The government may search and seize only materials expressly authorized by the terms of a search warrant. Here, the government was permitted to search all the Richmond materials, but authorized to search only evidence related to violations. There is nothing in the record to suggest the government made any attempt to identify documents, etc., and filter them out. This potential failure is more concerning because the warrant issued in August of 2019 specifically directs the government to identify what information was responsive to the warrant and instructed law enforcement personnel to then seal any information that does not fall within the scope of the warrant, which they did not do. The government appears to have conflated its obligation to protect privileged information with its duty to seize only those materials authorized by the court. By the summer of 2025, the FBI and U.S. Attorney's Office for the Eastern District of Virginia had initiated a criminal investigation into Mr. Comey. As part of the investigation, the FBI agent was instructed, with the concurrence of the USAO, to review a Blu-ray disc that contained a full Cellebrite extraction and reader reports of Mr. Richmond's iPhone and iPad backups, Cellebrite being a forensic examination tool. Inexplicably, the government elected not to seek a new warrant for the 2025 search, even though the 2025 investigation was focused on a different person, was exploring a different legal theory, and predicated on a different set of criminal offenses. This is highly unusual. The court recognizes that seeking a new warrant under these circumstances would have required a fresh legal analysis and likely resulted in some delay, a delay the investigative team could not afford, given the statute of limitations would expire in a mere 18 days. If a new warrant had been sought by the government, the Fourth Amendment would have required it to be narrowly tailored, authorizing access only to materials within a limited time frame and relevant to the new offenses. Any new warrant would have imposed strict procedural safeguards to ensure privileged information was not reviewed by the prosecution team. The parameters of the 2025 search would inevitably have been different. Faced with this prospect, the government chose to unilaterally search materials that were 1. Seized 5 years earlier, 2. Seized in a separate and since closed investigation, 3. That were never reviewed to determine whether the seized information was responsive to the original warrants, 4. That were likely improperly held by the government for a prolonged period of time, 5. That included potentially privileged communications, 6. Did so without ever engaging the privilege holders, and 7. Did so without seeking any new judicial authority. Having decided to forge ahead under these highly unusual circumstances, the FBI agent conducting the September 12th search of the disk was specifically instructed to seize conversations between Mr. Richmond and Mr. Comey. There appeared to be no precautions in place to avoid the collection of privileged communication. The agent conducted the review and printed the relevant pages, which included multiple conversations involving Mr. Comey and Mr. Richmond. The reviewing agent then transferred the disk and the relevant printed pages. Sometime between September 12th and 25th, Agent 2 reviewed the newly seized materials and, not surprisingly, identified communications involving Mr. Comey and Mr. Richmond as potentially privileged. The government presented this case to the grand jury September 25th. The same day, prior to the grand jury presentment, Agent 2 alerted the lead case agent and an attorney in the FBI's Office of General Counsel that evidence obtained in the government's investigation of James Comey may constitute attorney-client privileged or confidential information. Privileged means they can't make me, and client confidential means I can't tell anyone. It is possible that agents may have obtained evidence that constitutes attorney work product information. Agent 2 gave Agent 3 and the FBI attorney a limited overview of the privileged communications. Agent 3, rather than remove himself from the investigative team until the taint issue was resolved, proceeded into the grand jury, undeterred, and testified in support of the pending indictment. Agent 3 was the only witness to testify before the grand jury in support of the pending indictment. The government's decision to allow an agent who was exposed to potentially privileged information to testify before a grand jury is highly irregular and a radical departure from DOJ practice. Only after the government had reviewed the materials seized pursuant to the search warrants, only after FBI agents had personally identified potentially privileged materials, only after the government obtained an indictment on September 25th did it seek approval of filter protocols for materials the FBI had already reviewed. The horse is already out of the barn. For reasons that remain unclear, the government waited 31 days then, the date the FBI began reviewing the materials, September 12th, and 18 days from September 25th, before seeking court approval of a filter protocol on October 13th. The court's in-camera review, which means in person. Only one witness testified before the grand jury. The government's position is that the grand jury materials confirm the baselessness of the defendant's claim that privileged information may have been shared. While it is true that the undersigned did not immediately recognize any overt privileged communications, it is equally true that the materials seized from the Richmond warrants were cornerstone of the government's grand jury presentation. The government substantially relied on statements involving Mr. Comey and Mr. Richmond in support of its proposed indictment. Agent 3 referred to those statements in response to multiple questions from the prosecutor and from grand jurors, and did so shortly after being given a limited overview of privileged communications between the same parties. The government's position that privileged materials were not directly shared with grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's prosecution, and therefore improperly inform the grand jurors' deliberations. Having been requested by the government to review the grand jury materials, the court has identified 2 statements by the prosecutor. These statements are redacted, so we're going to skip over this part for now. We'll pick up here. The record is well established that the grand jury was originally presented with a 3-count indictment signed by the prosecutor. The grand jury rejected count 1. We've gone over this. A second indictment was prepared. Both indictments were fully executed by the grand jury foreperson and the prosecutor. Presented with 2 facially inconsistent indictments, the judge questioned the grand jury foreperson and the prosecutor to unwind this procedural knot. The judge accepted the return of the second signed indictment. The second indictment was a new indictment, and therefore the undersigned concluded, after reviewing the grand jury transcript, that the prosecutor would have presented the second indictment to the grand jury for consideration before it was returned in open court. It now appears that may not have happened. November 14th, the prosecutor, Lindsay Halligan, filed a declaration with the court attempting to address the issue of whether the transcript the grand jury proceedings filed with the court was a full and complete transcript. The prosecutor stated that the grand jury was left to deliberate the first indictment. She had no further contact with the grand jury. The prosecutor further stated that she was notified by the first assistant U.S. attorney that the grand jury returned a true bill on only 2 of 3 counts. She prepared the second indictment, and a hearing was held at 6:47 p.m. The short time span between the moment the prosecutor learned that the grand jury rejected 1 count and the time the prosecutor appeared in court could not have been sufficient to draft a second indictment, sign the second indictment, present it to the grand jury, provide legal instructions, give them an opportunity to deliberate and render a decision on the new indictment. If the prosecutor is mistaken about the time she received notifications, then the transcript and audio recording provided to the court are incomplete. If this procedure did not take place, then the court is in uncharted legal territory, in that the indictment returned in open court was not the same charging document presented to and deliberated upon by the grand jury. Either way, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity generally associated with grand jury proceedings, and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. Authority that may support a motion to dismiss. The government argues the defense has failed to meet its heavy burden to satisfy the standard that grounds may exist to dismiss the indictment because of a matter that occurred before the grand jury. The validity of an indictment is not affected by the character of the evidence considered. Courts have likewise held that grand jury's considerations of evidence obtained in violation of attorney-client privilege does not constitute grounds for dismissal of an indictment. However, the government's claim that this is at worst a conventional Fourth Amendment violation and an excusable slippage of privileged communications is unpersuasive, particularly considering the central role this information played in the government's grand jury presentation. It is well established that courts may, and indeed must, use their supervisory authority to safeguard the integrity of the grand jury process. The Supreme Court has recognized a district court may use its supervisory power to dismiss an indictment because of misconduct before the grand jury, at least where the misconduct amounts to a violation of one of those few clear rules which were carefully drafted and approved by this court and by Congress to ensure the integrity of the grand jury's functions. The Supreme Court has also recognized that this supervisory power of federal district courts should be used to implement a remedy for violations of recognized rights to preserve judicial integrity by ensuring that a conviction rests upon appropriate considerations validly before the jury, and finally as a remedy designed to deter illegal conduct. Accordingly, when prosecutorial misconduct before the grand jury prejudices a defendant and threatens the defendant's right to fundamental fairness in the criminal process, a district court may exercise its supervisory authority to dismiss the indictment. Here, The procedural and substantive irregularities that occurred before the grand jury and the manner in which the evidence presented to the grand jury was collected and used may rise to the level of government misconduct, resulting in prejudice to Mr. Comey. Based on the foregoing, the court makes the following findings. First, the facts establish a reasonable basis for the defense to challenge whether the Richmond warrants were executed in a manner consistent with the Fourth Amendment and the orders of the issuing court. Second, the facts establish a reasonable basis for the defense to challenge whether the governments exceeded the scope of the Richmond warrants by seizing and preserving information that was beyond the scope of the warrants. Third, the facts establish a reasonable basis for the defense to challenge that the government had lawful authority to search the Richmond materials anew in 2025. Fourth, whether the government's seizure of the Richmond materials included information beyond the scope of the original warrants. Fifth, the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. Sixth, the defense might show they were prejudiced by the government's use of the Richmond materials in the grand jury, particularly if the government's conduct was willful or reckless, given the centrality of these materials to the presentation. Whether the government took steps to avoid the collection and review of privileged materials. Whether privileged information was used directly, indirectly by the government to prepare the grand jury presentation. The nature and circumstances, ninth, the nature and circumstances surrounding the disclosure of potentially privileged information establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. This is particularly significant because Agent 3, after having been exposed to said potentially privileged information, chose to testify anyway. 10th, the prosecutor made statements to the grand jurors that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. 11th, the transcript and recording of the grand jury proceeding likely do not reflect the full proceedings, although it is clear that a second indictment was prepared and presented to the grand jury. The transcript and audio recording of the proceedings do not reflect any further communications after the grand jury began deliberating the first indictment. Collectively, the facts set forth herein and the findings of the court establish that grounds may exist to dismiss the indictment because of a matter that occurred before the grand jury. The court need not now determine whether any facts herein have been proven or whether there is any merit to a motion that's been filed. That task lays ahead. The court is finding that the government's actions in the case, whether purposeful, reckless, or negligent, raise genuine issues of misconduct, are inextricably linked to the government's grand jury presentation, and deserve to be fully explored by the defense. I'm just going to skip. The court recognizes that the relief sought by the defense, the disclosure of grand jury materials, is rarely granted. However, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding. Therefore, in this case, the court has before it a rare example of a criminal defendant who can actually make a particularized and factually based showing that grounds exist to support the proposition that irregularities may have occurred in the grand jury proceedings and may justify the dismissal of one or more counts of the indictment. Accordingly, the defense request for all grand jury materials is granted. 17th day of November 2025. I know that was a long one. I'm looking at an hour ticking over on the clock here, but it's also a remarkable hour. Every defendant makes some kind of similar motion, a vindictive prosecution, prosecutorial misconduct, something like that. You don't ever see them get granted. This one is on the flip side. Why so many things were said about this man? If you want to prosecute him. Don't go and say all the things and then prosecute him. But man, there was so much more in the background with the searching of previous search warrant materials that were probably not includable in this litigation, in this indictment. Some of the information, sure, but you'd have to do the procedure to clear it first, and they didn't apparently do that. For the prosecutor to just have the foreperson sign a new document and not present the new indictment, even if it's the same text of the second and third counts, still has to be presented to them. Maybe they don't deliberate very long. Maybe they just agree and then vote and then sign. That's fine, but it wasn't done. And all of this added together is way more than enough, I think, for this indictment to be dismissed. I am no fan of James Comey. I do not like the way he inserted himself into the 2016 election. I believe that it did affect the outcome of the 2016 election. I don't know. I don't have any more than that. I'm not trying to say that it would have changed the outcome. Maybe it would have. I don't know. But I did not like that kind of stuff. I similarly did not like, Joe Biden being, or Kamala Harris being appointed the candidate without a primary. I thought Kamala Harris was an okay candidate, but she should have been primaried, not, she should have won her candidacy through a primary, not been appointed by the party. So there's room here for debate over whether Comey did anything wrong. What there's not room here for is that the Trump administration and the Department of Justice said and did a whole bunch of irregular things that you would not normally do to try to get this guy. If he's worthy of getting got, great, go get him but follow the freaking rules. It's why we follow the rules. It's because we want the prosecution to be solid. We want the charge to be solid. We want the conviction to be solid. If it's not, he's got every opportunity to undo it. He's able to undo it here with 4 motions to dismiss before we've even gotten started. There are 212 docket entries before we've even gotten started. That's how highly irregular the prosecution is in this case, giving an experienced prosecutor himself all the ammunition, all the opportunities that he needs to attack the case. He will never be convicted because this thing will never see the light of day. They've given him every opportunity to delay it and attack it over and over again. Even if they did get to a jury trial, and even if he did get convicted, he's got every reason to make every motion to have that jury verdict overturned and then to appeal if it's not overturned. It's terrible. It's obvious to me that they're just harassing this man, even though he may have done something to deserve attention at one time. It is way past that point, in my opinion. And I do not think this is the kind of attention it would have deserved. It would have deserved a normal investigation, and then upon concluding the investigation, you charge or don't charge. It kind of sounds like that was done with Todd Siebert. And so one of the things the court is now looking for is the declination memo, which is where the prosecutor decides not to prosecute. So if Todd Siebert declined to prosecute and then Halligan's appointed and she decides to prosecute, the judge wants to see that, to see what's the difference here. What are the reasons the government is doing this? Anyway, thank you for joining me today. That is all I have for you. I hope that was interesting and entertaining and educational. I love you all. I'm Leonard French, your favorite copyright attorney, and I will see you in the videos that drop. Bye.